Good afternoon, everybody. It is Saturday. What is it? December the 20th? And I'm Wendy. This is Sinister, and welcome. First, I want to touch on the Aaron Spencer case for a minute before we start reading the motion denied, or the denial of the motion in the Stines case. He had two pretrial hearings this week, and one on Tuesday, and then it got carried over to Wednesday morning. And I'm not sure what time it started, but I know that Judge Elmore wanted them to be done by 10:30 because she had someplace or something to do. And all I have to say to that is, shame on you, Judge Elmore. Aaron Spencer is guaranteed a fair trial. All defendants are. And if you can't give him the time that he needs to put on his defense, you need to step aside and have another judge appointed to this case. I realize you have other cases. I realize whatever. But I would think that the judge assigned to a case who, if he loses, will be put in prison for the rest of his life. I would think if I were the judge on that case, it would take precedence for the foreseeable future. I mean, this isn't a shoplifting case, even though that defendant would deserve a fair trial as well. This is a trial. This is a case where if Aaron Spencer loses, he goes to prison for the rest of his life. So for the foreseeable future, I would suggest that you keep your calendar open. That's just my opinion. And it means nothing to Judge Elmore. It means nothing probably to anybody. But I'm just saying, be a little bit more present for the big ones, especially. I mean, is that asking too much? What if he's not done by 10:30? What are you going to do? Kick him out of the courtroom? This isn't right. If you have something else to do at 10:30 in the morning, you should not have continued the pretrial hearing for before that. Maybe you should have scheduled it after whatever you have going on at 10:30. Or maybe you should have just rescheduled it for another day. I don't know, but it's not right to say that you have a time limit when his life is on the line. So there's that. That's all I have to say about that. And let's move on with the Mickey Stines case. Ex-Sheriff Mickey Stines, as you all know or may not know, is on trial for murder because he shot Judge Mullins multiple times, emptied his gun, I believe, in Judge Mullins' chambers, which was also videotaped. There's no sound to the video, so nobody knows what they're saying. But it is a pretty disturbing video to watch. Because, they were friends. They had just had lunch together in front of tons of witnesses who say that they seemed to be getting along as normal. There was no tension in the air. All they remember is that Judge Mullins asked Mickey Stines, do we need to have a word in my chambers? Meaning, I assume meaning, do we need to speak privately? That was it. That's all anybody heard that sounded even remotely questionable. But according to the video of Mickey Stines' chambers, it tells something different. So, I don't know. They're not finding anything for the Mickey Stines case is virtually impossible. You go to the court website and You can't see anything. All it shows you is his name. I don't even think it shows you what he's charged with. It just shows you his name, and there's no way to if you ask the court clerk for copies of any of the court documents, she says no. The only people that are able to acquire them apparently are media, mainstream media, that is. And that's it. It's impossible to get any documents, any court documents for this case, and I don't believe it's going to be televised. I was looking for information about his next court date, and I couldn't even find that. They're moving very slowly on this case. They haven't even decided if they're going to change venues yet. So I don't know when it's going to happen, if it's going to happen. It seems like they're dragging their feet, and I don't know why. But he is being held without bail. And apparently this week they had a hearing, which I knew nothing about. And it wasn't in any of the records that I looked at. There was no mention of a hearing this week. But anyway, he was told that he could have a bail hearing. So I will notify anybody when that is, if I'm able to find that out. But like I said, I looked everywhere for his next trial date, and nowhere did it say that he had a hearing, a pre-trial hearing this week. And lo and behold, he did. So I have gotten my hands on the denial for his motion to dismiss charges. And I've also gotten my hands on the transcript for the grand jury hearing to indict Mickey Stines. And then I believe I got my hands on Mickey Stines' deposition also. So, and maybe Detective Stamper's testimony to the grand jury. So we're not going to cover all that tonight because that's way too much. But this denial of motion is 15 pages alone. So that's all we're going to do tonight. So without further ado, let's get to it, shall we? Is everybody ready for Christmas? Because I'm as ready as I'm going to be. I'm ready for it to be over. I know that. As you know, I'm not a Christmas person. So I hope everybody's enjoying their Christmas holidays. Yeah, holiday season. Got all their shopping done, so they don't have to stress about last minute shopping. That's always nice. So here we have it. Order denying motion to dismiss indictment. In November 2024, a Letcher County grand jury indicted the defendant, Sean Stines, for committing murder. The defendant seeks dismissal of the indictment on 2 grounds. The defendant alleges that 1, at the November 21, 2024 grand jury meeting, the prosecutor elicited false and misleading testimony which influenced the jury to return the murder indictment. And 2, at the preceding October 17, 2024 grand jury meeting, the prosecution intentionally failed to record the proceedings. The Commonwealth denies the allegations for reason expressed below. The defendant's motion to dismiss indictment is denied, in all caps. So I know in regular court, there's a court reporter or court recorder, I guess she's called. Is there not a court recorder in the grand jury? And why? Shouldn't everything in the grand jury be recorded just for shits and giggles, if nothing else? Because if they don't record everything that happens in the grand jury, it's a he said, she said situation. And I realize that it's only the prosecution that gets to put on their case and their evidence, but still, it's still a he said, she said at that point. I thought everything had to be recorded when it came to hearings and whatnot. Relevant factual and procedural background. On September 19th, 2024, the defendant, then the Letcher County Sheriff, shot and killed Letcher County District Judge Kevin Mullins. The event occurred in Judge Mullins' chambers and was recorded on video. The defendant was arrested and charged with murder the same day. The video footage showing the defendant shooting Judge Mullins, defendant's October 1, 2024 preliminary hearing and entered into the record as an exhibit. The same video footage was played for the Letcher County Grand Jury, convened November 21, 2024, the meeting at which the Commonwealth sought and the grand jury returned an indictment charging the defendant with murder. Yeah, this video, it's crazy because you can't tell at any point in time until he gets up and tries to hide that there's any kind of animosity or any kind of argument going on. They're both seated. Judge Mullins is seated behind his desk and Sheriff Stines is in front of his desk. They're talking and Judge Mullins hands Mickey Stines his phone across the desk. Mickey Stines makes a phone call from it. And we found out later that the phone call was ultimately to his daughter. He hangs up the phone. He hands the phone back to Judge Mullins. He eventually stands up, pulls up his pants, adjusts his belt or whatever. And next thing you know, he has his gun in his hand and he points it at Judge Mullins, shoots. Judge Mullins gets up, tries to hide under his desk, tries to cower in the corner. And Mickey Stines just keeps shooting him over the desk. And when Judge Mullins tries to climb under his desk, Mickey Stines walks around the desk and stands over him and just unloads. Now, there's at no point in time did Judge Mullins look threatened. When Mickey Stines first lifted his gun, Judge Mullins put his hand up a little bit, but even then, it didn't look like he felt threatened. It was crazy. It was there's no sound, so you don't know what's being said while he's shooting him. But it's a really disturbing video. And there's not blood or anything because I believe he had his judge's robe on. So you don't see where any of the bullets hit, but I mean, obviously they did hit. Prior to the Letcher County Grand Jury meeting in November, on October 17th, 2024, the special prosecution assigned to this case requested the Letcher County Grand Jury issue a subpoena for the defendant's recent medical records, including mental health and pharmacy records and Letcher County Detention Center records. Now, I don't know why they would want the detention center records unless they want to see how he acts when he doesn't realize he's being watched or something. Maybe they think he's faking it. I don't know. At the November 21, 2024 grand jury meeting, Kentucky State Police Detective Stamper testified about the investigation of Judge Mullins' death and recounted the events shown on the video. Detective Stamper also testified about information provided by Judge Mullins' family, friends, colleagues, and medical records. The medical records were provided to the grand jury. I can't think of a reason why they would need the judge's medical records because nobody's claiming that he died of natural causes and nobody's claiming anything about his health. So I'm not sure what his medical records would ultimately prove or disprove. Okay. On June 4th, 2025, the defendant filed a motion to dismiss the indictment based upon the prosecutor's actions at both the October 17th, 2024 and November 21st, 2024 Letcher County Grand Jury proceedings. On June 27th, 2025, the Commonwealth filed a response. Oral argument was held August 15th, 2025. The defendant filed his brief in support of the motion to dismiss the indictment on September 2, 2025. The defendant provided to this court, in support of the motion for dismissal of the indictment, a transcript of Detective Stamper's November 21, 2024 Letcher County Grand Jury testimony. The transcript is filed under seal, but I have it, so I'm not sure if I'm supposed to have it. I guess I don't know. Reflected below, as allowed under RCR 524, the defendant and the Commonwealth cite portions of Detective Stamper's testimony in their filings. Analysis. The defendant presents two arguments for dismissal of the indictment. As to the November 21st, 2024 Letcher County grand jury proceeding citing Baker versus Commonwealth, the defendant argues that the Commonwealth elicited false and misleading testimony which prejudiced the defendant and tainted the grand jury proceedings. As to the October 17, 2024 Letcher County grand jury proceeding, the defendant argues that the Commonwealth violated a Kentucky rule of criminal procedure. A. The record does not support a conclusion that the defendant was prejudiced by prosecutorial misconduct before the grand jury. Sorry about that. I'm trying so hard because all of a sudden I've developed a lisp of some sort, and it comes and goes. And so I'm trying not to sound drunk on my videos. And I think I'm trying so hard that I'm making it worse. So if I sound drunk, I'm not. I'm just trying really hard to overcome a lisp that I have developed late in life. And I'm not sure how to work around it. So just be patient, and I'm just believe that I'm not drunk. I talk really, really, really fast, and I'm also trying to not do that, which may be part of the problem. But I know that that's not what gave me a lisp. So anyway, sorry. The defendant brings two claims related to Detective Stamper's testimony during the November 21, 2024 Letcher County grand jury meeting. He claims that, one, the statement by Detective Stamper that the defendant was in his sane mind, and that, two, the statement by Detective Stamper that the Benfield civil case was not, quote, not related in any way, end quote, are false and intentionally misleading. Now, I don't know about you, but I don't feel like it's the detective's place to say whether or not he was sane at the time of the shooting. A, he wasn't there. He's only watched the recording like anybody else. And two, or B, he's not a licensed psychologist or psychiatrist, as far as I know. So why does his opinion about his sanity at the time of the shooting matter? Why are we even listening to that? Just a question. Asking for a friend. 1. State of mind. During the Commonwealth's presentation to the grand jury, the grand jurors asked Detective Stamper questions about the medical records received from the subpoena issued. In particular, a grand juror asked Detective Stamper if the doctor, quote, documented any type of hallucinations, psychosis, depression, any mental health issues, end quote. The prosecutor then handed to Detective Stamper the medical records returned from the request and asked him to read the doctor's history of present illness comments. Now, see, I don't think that they should have the right to read that to anybody. Another grand juror followed later with a similar mental health question. Quote, so the doctor said pretty much no mental health issues, but was there any major physical health issues that he was struggling with that might have affected his mental health? End quote. Detective Stamper responded, no, not that I'm aware of. The last related question posed by a grand juror was, quote, so he was in a sane mind as far as the investigation has gone. Detective Stamper responded, yes. According to the defendant, the Commonwealth and its witness did not, it's hard for me to read under that stamp, did not disclose that in the same records from the day before the shooting. The defendant's doctor diagnosed an acute stress reaction. So that can affect your mental health. Definitely, I would think. The defendant views the Commonwealth as representing to the grand jury jurors that there was nothing on note in the medical records, and the diagnosis from the September 18, 2024 doctor visit makes it evident that representation was untrue. Excuse me, makes it evident that representation was untrue. The defendant also states that the Commonwealth's witness failed to report the contents of the quote-unquote jail triage clinical follow-up risk assessment, a suicide risk assessment conducted on the defendant September 23rd and 24th, 2024. The defendant describes the assessments as including observations of quote-unquote active psychosis and the jail records as informing that the defendant had been given risperidol and Seroquel prior to the assessment. So it sounds to me like in his assessment in the jail that they did make a note of acute psychosis, and they gave him Seroquel and what was the other one? Seroquel and risperidol, which are both pretty strong sedatives. Not they're psych meds, I believe. And so to have him on both of those to me says something that the Commonwealth is not willing to admit at this point. Okay. Where are we? Okay. And yet, during their assessment, they still noted active psychosis. That's under the effects of these two medications, because they gave these medications prior to the assessment. The defendant claims that despite overwhelming evidence to the contrary, inclusive of Kentucky State Police interviews, which the defendant summarizes in his brief as calling into question the defendant's mental status in the week preceding the shooting. Because remember, all his friends and family are saying that he was not acting like himself the week prior to the shooting. And I think it was like 3 days before the shooting, he was on the phone with his lawyer for the civil case. And he was saying all kinds of strange stuff. And when he hung up, the lawyer actually looked at his wife and said, he's fucking lost it, or he's fucking crazy, or he's fucking losing his mind or something. And, and multiple people have come forward to say that Stines was not acting normally in the days leading up to the shooting. So was he having some kind of psychosis? It sounds like, yeah, he could have. Detective Stamper and the Commonwealth put on testimony that the investigation showed the defendant was quote-unquote in his sane mind, which, again, I don't know how they can make that judgment. The defendant argues that when Detective Stamper stated agreement with the grand juror's question, quote, so he was in a sane mind as far as the investigation has gone. Detective Stamper's testimony was intentionally misleading and prejudicial to the defendant. The defendant concedes that when seeking an indictment, the Commonwealth is not required to put on exculpatory evidence nor evidence demonstrating lack of criminal responsibility, that there is not a requirement for the Commonwealth to put on evidence absent a grand jury request, that the Commonwealth did not have to go into mental health at the charging juncture, and that Detective Stamper was not prohibited from commenting about the defendant's mental state. The defendant, however, argues that when the grand jury decided on its own that it wanted to investigate the defendant's mental health, the Commonwealth was not free to mislead or lie to the grand jurors. The defendant contends that as the grand jury sought additional information to make their decision whether to indict and upon what charge to indict, had the Commonwealth presented truthful and accurate testimony to the grand jury about the defendant's sanity, despite seeing a portion of the video evidence, the defendant likely would not have been indicted, or at least he would not have been. That's a strong statement. 2. Field's case. During the course of answering the grand juror's questions, Detective Stamper also informed the grand jury that there was an active lawsuit against the Letcher County Sheriff's Office. A grand juror asked Detective Stamper whether Judge Mullins had any relation to that lawsuit in any way that would matter. The Commonwealth then asked Detective Stamper, quote unquote, to your knowledge, was Judge Mullins involved? Detective Stamper stated, quote, no, to my knowledge, no. No, no involvement, end quote. The grand jurors did not ask further questions about the lawsuit. As described by the defendant, the referenced federal civil litigation, Adkins v. Fields, is about Ben Fields' improper sexual relationships with court participants. The defendant lists sources of information, particularly KSP investigations and interviews. So, in case you're not up to date on this, it was found out that Fields, Officer Fields, who was a deputy to sheriff, was letting women perform sexual favors for him in order to be released from house arrest. He would take their GPS bracelets off or anklet off if they performed sexual favors for him. And one of those victims came forward and filed a lawsuit against not only Fields, Officer Fields, but also Mickey Stines and the Sheriff's Department. She holds Mickey Stines responsible because she says that it was under his watch. So I don't know if that's what caused Mickey Stines to have, to go into a psychotic state or a state of psychosis, but it could be the stress of that. Just one second. Okay. So that, could be a contributing factor to his state of psychosis. Yes, definitely. Okay, I stopped in the middle of a sentence, apparently. The defendant lists sources of information, particularly KSP investigations and interviews. He believes contradict Detective Stamper's statement that, to his knowledge, Judge Mullins was not involved in the Fields case. It's hard to read. They stamped right over the words at the end of each line, or at the end of the top line on each page. The defendant states that the KSP investigation made it very clear that the events of the federal civil lawsuit occurred in Judge Mullins' chambers. That's right. Officer Fields performed these sex acts in Judge Mullins' chambers. So it's hard to believe that Judge Mullins didn't know anything about it. The defendant also describes KSP interviews, which he believes imparts a basis for concluding that Detective Stamper and the Attorney General itself had at least constructive knowledge of related allegations which connected Judge Mullins to the Fields case. The defendant asserts that the Commonwealth's choice to not disclose the allegations and rephrase the grand juror's question to allow Detective Stamper, quote, to state that there was no relation in any way between Judge Mullins and Fields' case, end quote, is a knowing presentation of misleading testimony. I agree. The Commonwealth counters that the defendant's motion is conflating the role of the grand jury proceeding with the criminal trial. The Commonwealth also asserts that, as reflected in the grand jury recording, I thought there wasn't a recording. The grand jurors were provided the opportunity to ask any questions. Multiple grand jurors did, in fact, pose questions to Detective Stamper, which he answered based upon his investigative knowledge, and only when there were no additional questions for the grand jurors did Detective Stamper's testimony. The Commonwealth states that upon reviewing the recording of Detective Stamper's grand jury testimony, it has been unable to identify any questions lodged by the grand jurors that were not answered by Detective Stamper within his personal knowledge. The Commonwealth argues that the defendant fails to demonstrate both the Commonwealth argues that the defendant fails to demonstrate both the requisite conduct on the part of the prosecution and actual prejudice as required by Baker to merit dismissing the indictment. The grand jury is an investigative body acting independently of either prosecuting attorney or judge. Internal quotation and citation omitted. Okay, I don't know what that means. The hallmark of the grand jury is its independence from outside influence. Democratic Party serves the Democratic Party of Kentucky versus Graham, Kentucky. It serves the invaluable function in our society of standing between the accuser and the accused, whether the latter be an individual, minority group, or other, to determine whether a charge is founded upon reason or was dictated by an intimidating power or by malice and personal ill will, end quote. Hoskins v. Miracle. A grand jury's role is to determine whether a prosecutor's evidence provides probable cause to issue an indictment. Quote, the grand jurors shall find an indictment where they have received what they believe to be sufficient evidence to support it, end quote. Probable cause is not a high bar. Quote, in dealing with probable cause, the grand jurors deal with probabilities. These are not technical, they are the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. The substance of all the definitions of probable cause, quote, is a reasonable ground for belief of guilt. Accordingly, as the grand jury is an accusatory body and not an adjudiciary body, it, quote, has always been thought sufficient for the grand jury to hear only the prosecutor's side, end quote. The presentation of exculpatory evidence is not required, and the introduction of hearsay is allowed. So basically, what they're saying is everything that's not allowed in a trial is allowed at the grand jury proceeding. And the grand jury only hears the prosecution side of the story. The defense is not allowed to go. And I find that to be so hypocritical because, you know, one of the main things in our justice system is to guarantee a defendant a fair trial. And I ask you, how can it be a fair trial if the very first step in the process, which is getting an indictment, obtaining an indictment from the grand jury, is already prejudicial and one-sided? They should both be allowed into the grand jury, and the grand jury should hear both sides of the case before returning an indictment. The fact that they only get to hear the prosecutor's side and the prosecution can present hearsay in their presentation to the grand jury is bullshit. How is that fair? And yet we go on and on and on and on and on and say every defendant is awarded a fair trial. It is one of the most important things in our Constitution. And yet the first step of their trial, their fair, quote unquote, fair trial, is to present the case to the grand jury to obtain an indictment. And the only side that gets to present their case is the prosecution. How is that fair? So from the get-go, it's unfair. And for them to say it's not is bullshit. And I can never understand that. And they don't have to show overwhelming evidence, and it doesn't have to be sculpatory. And they can use hearsay. And to me, it's just so one-sided that it's sickening. And I don't understand how that is allowed. Something like that needs to be changed. And I doubt if it ever will, but I just don't understand it. And maybe I'm just dumb. I don't know. But it just, every time they talk about a grand jury indicting somebody, it just pisses me off, because it's like, well, anybody can. That's why the saying goes, you can indict a ham sandwich, because you can, because they only hear one side of it. You can say whatever you want to get that indictment. While establishing probable cause is not a high bar, and, quote, an indictment returned by a legally constituted and unbiased grand jury, if valid on its face, is enough to call for trial of the charge on the merits. I can't read none of this. A trial court may dismiss an indictment for prosecutorial misconduct. However, the standard for dismissal is a high bar. So basically, getting an indictment is a low bar, but proving that the prosecution did it illegally or misrepresented is a high bar. Got it. In Bank of North Nova Scotia, the United States Supreme Court considered the role of the federal harmless error rule, a rule comparable to Kentucky's, when the trial court is asked to dismiss an indictment for prosecutorial misconduct. The United States Supreme Court concluded that a district court exceeds its powers in dismissing an indictment for prosecutorial misconduct not prejudicial to the defendant. The United States Supreme Court concluded that when dismissal is sought for non-constitutional error, the dismissal may be properly granted, quote, if it is established that the violation substantially influenced the grand jury's decision to indict, end quote, or, quote, if there is grave doubt that the decision to indict was free from the substantial influence of such violations. In Baker, the Kentucky Court of Appeals adopted the harmless error standard pronounced in Bank of Nova Scotia and its consideration of other federal authority. Explained that a court may utilize its supervisory power to dismiss an indictment when a prosecutor knowingly or intentionally presents false, misleading, or perjured testimony to the grand jury that results in actual prejudice to the defendant. Quote, generally, a defendant must demonstrate a flagrant abuse of the grand jury process that resulted in both actual prejudice and deprived the grand jury of autonomous and unbiased judgment, end quote. In Baker, a mother was reported to the Division of Social Services for striking her two daughters, ages 14 and 16. When the Commonwealth sought an indictment charging the mother with assault in the second degree, rather than the investigating officer appearing before the grand jury, his supervising officer appeared and testified about two beating incidents. The prosecutor asked the officer if the mother struck her children with a baseball bat. What? And if the mother, quote, acknowledged that she did strike her children about the body with an aluminum bat. What? The officer answered each question affirmatively, so he lied. However, there was no evidence to support the testimony. Evidence indicated the mother had used a wooden stick. The grand jury returned an indictment charging the mother with 6 felony counts of assault in the second degree. The indictment charged that the mother had committed the crimes by wantonly causing serious physical injury to her two daughters by means of a deadly weapon or dangerous instrument. And she hit him with her hand, remember. Slapped him with an open hand. The mother eventually moved to dismiss the indictment because the indictment was based on false testimony. At an evidentiary hearing, the officer who testified before the grand jury admitted that he had little knowledge about the case and conceded that there was no evidence that a baseball bat missed the indictment, as it should. The trial court concluded, in part, that the police officer's testimony concerning the use of an aluminum baseball bat was materially false, and that it affected the grand jury's decision whether to indict the mother on the assault charge, obviously, which required the use of a deadly weapon. The trial court also found that the Commonwealth's attorney had knowingly recklessly elicited false testimony before the grand jury through leading and suggestive questions. And the police officer voluntarily testified even though he had no personal knowledge of the facts of the case. The Kentucky Court of Appeals stated that the trial court's finding that the prosecutor knowingly or intentionally presented false information to the grand jury was amply supported in the record. The Court of Appeals also agreed with the trial court that the false testimony prejudiced the mother by influencing the grand jury to indict because the officer's responses to the Commonwealth's questions was the only evidence presented to the grand jury. At base, Baker presents a two-part test. 1, was there prosecutorial misconduct? And 2, if so, was the misconduct actually prejudicial to the defendant? The defendant states within his brief in support of motion to dismiss indictment that, quote, the recklessly misleading information prejudiced the defendant in Baker and the facts in the case sub judice are significantly more prejudicial, end quote. God, I fucked that sentence up. The defendant also alleges that the Commonwealth misled the jury as a result of the reckless provision of information that is objectively untrue, and that the Commonwealth, quote, allowing the detective to make such a recklessly false statement about the mental health evidence falls well within what Baker describes as misconduct to the grand jury stage, end quote. And I agree, because he has no education or anything to back him up as far as how he knows whether somebody's sane or not. He doesn't have any kind of psychology or psychiatric knowledge. The defendant made similar oral arguments. However, it appears Baker's application to recklessly false statements has yet to be addressed. While the trial court in Baker made a finding that the Commonwealth's attorney had knowingly or recklessly elicited false testimony before the grand jury through leading and suggestive questions. The Court of Appeals concluded that the trial court's finding that the prosecutor knowingly or intentionally presented false information to the grand jury was amply supported by the record, leaving the question whether recklessly elicited false testimony would require dismissal of the indictment. Nevertheless, for the purpose of this analysis, it is assumed that both intentionally misleading or recklessly misleading statements fall under the Baker test. The facts in Baker are not comparable to the instant case. As a starting point, the Commonwealth's burden before the grand jury was to present evidence which provided probable cause to believe that the defendant committed murder. That is, with intent to cause the death of another person. Here, Judge Mullins, he caused the death of such person. The Commonwealth satisfied that burden. As noted above, the prosecutor played the video footage showing the defendant shooting Judge Mullins multiple times. That evidence alone removed the question of who shot and killed Judge Mullins. The video footage clearly serves as a reasonable ground for belief the defendant intended to cause the death when he shot and killed Judge Mullins. I'd have to agree, you empty a gun on somebody, they're most likely going to die. The Commonwealth also addressed the grand jurors' questions, including those related to the defendant's mental and physical health. Although the testifying officers' express answers may not have been as complete as the defendant suggests they should have been, based upon the defendant's review of discovery or the defendant's knowledge of the field's investigation. Answer to the grand jury's questions, the medical records were provided to the grand jury, and as discussed during oral argument, the Commonwealth's rephrasing of a question so that its witness testifies based upon personal knowledge is not uncommon. Upon review of the grand jury hearing, there is no indication of an intentional or reckless misstatement or omission by Detective Stamper. Taking the analysis a step further, even if it were concluded that the Commonwealth or its witness intentionally or recklessly omitted that the doctor diagnosed the defendant with an acute stress reaction, omitted that the detention center suicide risk assessment included observations of active psychosis, failed to provide the jail records to the grand jury, or misrepresented there was no relation between Judge Mullins and the Fields case. Under the probable cause standard and the video evidence presented, the alleged omissions and misrepresentation, alone or together, cannot be viewed as making a difference in the grand jury decision to indict the defendant. That is, even when viewing the defendant's allegations as true, the court has no quote-unquote grave doubt that the Letcher County grand jury's decision to indict the defendant for the murder of Judge Mullins was free from the substantial influence of such violations. Bank of Nova Scotia, 4837 U.S. at 256. The defendant's motion to dismiss the indictment based upon prosecutorial misconduct is denied in all caps. And accordingly, in light of the foregoing analysis, there is no basis for the evidentiary hearing which the defendant requests. B, the Commonwealth did not violate RCR 516. During the Letcher County grand jury meeting on October 17, 2024, the special prosecutors in this case asked the grand jury to issue a subpoena for medical records and jail records. The prosecutor's meeting with the grand jury was not recorded. I don't understand. I thought all court proceedings were recorded. How do they know what anybody said is true? The defendant argues that RCR 516 was violated and the violation warrants dismissal of the indictment. The defendant asserts, without citing authority, that while the Commonwealth may classify the information presented in the grand jurors as something other than quote-unquote testimony, it is clearly related to the nature of the investigation and whether sworn or unsworn, the information constitutes testimony and should have been recorded. The Commonwealth disputes the allegation and states that when appearing before the grand jury, given the preceding preliminary hearing, local knowledge, and media coverage of the case, it did not require an introduction. The prosecutors informed the grand jury that they were investigating Judge Mullins' death and were requesting a grand jury subpoena for the defendant's mental health records. The prosecutors engaged in no peripheral commentary, and when the grand jury began asking questions, the prosecutors' responses were limited to explaining that the questions involved matters being investigated, and the matters would be presented to the grand jury at a later date. The Commonwealth states that because no testimony was provided to the grand jury, there is no recording. Well, the Commonwealth also states that the November 21, 2024 grand jury recording corroborates that the sole purpose of its attendance at grand jury in October was to obtain the grand jury subpoena. RCR 516-1 states in pertinent part that the attorney for the Commonwealth shall cause all of the testimony before a grand jury to be recorded. Allows a trial court to consider dismissal of the indictment as a remedy for violation. A violation of RCR 516 states that to have a record made, if required by paragraph 1 of this rule 516, shall be grounds for dismissal of the indictment unless the Commonwealth can show good cause for the failure. So they're trying to say that because they didn't record the grand jury hearing or presentation at that time, that it should be thrown out. But their Commonwealth is saying that they didn't present any testimony. They just asked the grand jury to come back with subpoenas for them to serve. And apparently that's not considered testimony, so that doesn't have to be recorded. The plain language and statutory interpretation principles support the Commonwealth position that it did not provide quote-unquote testimony when it met with the grand jury and requested the subpoenas. And therefore, RCR 516 was not violated when a recording of its request was not made. All words and phrases shall be construed according to the common and approved usage of language. But technical words and phrases and such others as may have acquired a peculiar and appropriate meaning in the law shall be construed according to such meaning, end quote. But additionally, Jackson v. Commonwealth, cited by the Commonwealth, instructs that RCR 516 does not mandate dismissal of an indictment, even in situations where testimony before a grand jury was not recorded. Jackson explains, the Commonwealth's attorney offered no explanation for the failure to record the presentation of the PFO. Sorry about all the noise. Are you trying to make noise? PFO evidence to the grand jury. Appellant asserts that this omission required dismissal of the indictment. However, the rule provides that failure to have a record made shall be grounds for dismissal of the indictment. Emphasis added. If dismissal were required under those circumstances, the rule would read, quote, failure to have a record made shall result with dismissal of the indictment, end quote. The rule was not intended to require automatic dismissal, but only to establish a grounds for dismissal. So the judge is saying that the rule does not say that it has to be dismissed. It says that it is grounds for dismissal, and it's up to the court's discretion whether or not to dismiss. So talk about mincing words. That's crazy. A ground for dismissal with the ultimate decision in that regard left to the sound discretion of the trial court. The PFO evidence consisted solely of the certified judgments of appellant's prior convictions. And he didn't have any prior convictions. He was a sheriff, right? So I don't know what they're talking about. Not factual testimony of an eyewitness to an offense. The fact of the prior convictions was uncontroverted, and appellant does not assert that the information contained in the PFO indictment was incorrect. Thus, he was not prejudiced by the Commonwealth's failure to record the grand jury evidence. We therefore conclude that the trial judge did not abuse his discretion in denying appellant's motion to dismiss the indictment. Thus, even if the Commonwealth's request for a subpoena were viewed as testimony, like in Jackson, the court finds no prejudice to the defendant from the Commonwealth's failure to record the request. In consideration of the plain language of RCR 516 and Jackson, the defendant's motion to dismiss the indictment is denied. For the foregoing reasons, the defendant's motion to dismiss the indictment is denied. All in caps, this third day of December 2025. And that is it. So, I don't know when his next court hearing is. I didn't even know this one happened. They're being very close lip about it, and they're making it impossible to get court documents. But like I said, I got my hands on the grand jury script and Sheriff Mickey Stein's deposition. So we will go over those maybe tomorrow, if not tomorrow, Monday. So I hope everybody's having a good weekend, and stay warm, stay safe, and I will see you later.